Hello and welcome to Workshops on the Web, presented by the Ventura County Superior Court. My name is Joanne Johnson and I am the Family Law Facilitator for the Superior Court. This workshop video consists of a video screen which operates like any other video player, with play, stop, and pause buttons. The text version of the presentation is in the right half of the screen. You will need to use the arrows or wheel on the mouse to advance through the text. The laws in California regarding the division of community assets and debts can be found in the Family Code, Rules of Court, Local Court Rules, and various cases which interpret these codes and rules. This video is designed to give you a basic understanding of the laws and procedures regarding division of property at time of divorce or legal separation. If you would like specific legal advice regarding your particular situation, you should consult with a private attorney. Registered domestic partners should consult with a tax professional or an attorney who is competent in the area of registered domestic partnerships, as federal laws regarding tax or division of certain types of assets are different for partners. In any divorce or legal separation case, the assets and debts of the parties must be characterized and divided. In California, property, assets or debts, is either community, separate, or a combination of community and separate. California is a community property state. This means that all property acquired during the marriage by a husband and wife is presumed to be community, owned or owed equally by both of them. There are some exceptions so that an asset or debt acquired during the marriage is deemed to be separate. Separate property is all property acquired before marriage, after separation, or during the marriage if acquired by gift or inheritance. Anything produced by separate property remains separate even if produced during the marriage. For example, the interest and dividends on funds in an account acquired before marriage remain separate even though the interest and dividends are paid during the marriage. There are a few exceptions which are discussed in detail later on, but common examples are student loans, workers' compensation awards, and support orders for other relationships. There are a few exceptions to the community separate characterization of property. Quasi-community property is any property acquired by either spouse while living outside of California that would have been community property if acquired while living in California. All states do not follow California's community property laws. If a spouse acquired property in another state that is not a community property state while living in that state, the property will be considered quasi-community and will be divided pursuant to California's community property laws in the divorce in California. Sometimes parties agree to hold title differently than as community, or agree to opt out of the community property laws in a prenuptial agreement. If this is your particular situation, you should speak with an attorney on how to proceed if the characterization of the property is in dispute. Before property can be divided, it must be characterized as either community or separate. In the case of mixed assets, the community and separate portions must be determined. The rules and laws regarding this characterization of assets are quite complex and are only discussed in general in this video. Complicated property issues usually require the services of attorneys or other professionals. The first step in determining the characterization of an asset or debt is the time it was acquired or incurred. The general during marriage rule resolves the majority of issues regarding the characterization of an asset, even if only one spouse worked and paid for the asset. A spouse's earnings during marriage are community, therefore anything purchased with earnings during marriage is community. Even if something was acquired during the marriage, if the parties take title in a manner contrary to community, this title may control. Frequently, title to real property may be taken in only one spouse's name at the suggestion of a lender. This is problematic because the other spouse usually must give up his or her interest in the property by way of a quitclaim deed. This seems like a good idea at the time to obtain a lower interest rate, but the party signing the quitclaim deed may be giving up his or her interest in the property. The source of funds used to acquire an asset can also be used to determine if the asset is community or separate. This is commonly referred to as tracing and will usually not overcome the presumption of title. A party may trace out a separate property interest in a community asset and obtain reimbursement of the separate property contribution, usually dollar for dollar. Likewise, the community may have paid into the loan on a separate asset and therefore acquires an interest in the separate asset. Unlike the reimbursement for separate property, the community acquires an interest in proportion to the contribution on the principal of the loan. There is a formula for determining the interest in real property when the community pays into one spouse's separate property, which is commonly known as the Moore-Marsden formula. An attorney can assist you with this calculation if this is your particular situation. The parties can agree, either before the marriage, during the marriage, or at time of separation, to characterize and divide their assets and debts as they wish, regardless of the community property laws. Prenuptial agreements are agreements by the parties prior to marriage. There are specific laws regarding prenuptial agreements set forth in Family Code Section 1600 to 1617. Due to the significant impact on a party's rights, any prenuptial agreement should be prepared by or reviewed by an attorney. Agreements during marriage are referred to as transmutation agreements, as they transmute or change an asset from either community to separate or separate to community. These agreements must be in writing and specifically state the party's intent. The most common type of agreement between the parties is a marital settlement agreement, or MSA. MSAs are entered into at the time of divorce or legal separation and divide the parties' assets and debts. The parties can agree to characterize and divide their assets however they wish. Once an asset has been characterized, it must be valued unless it is going to be sold and the proceeds divided or divided equally. If this is the case, there is no need to value the asset. If one party is going to buy out the other's interest or take the entire asset in exchange for another asset, the asset must be valued. The value of an asset is generally the fair market value of the asset at the time of division. It is not the purchase price or the replacement cost, but rather the price a seller would reasonably sell it for and what a buyer would reasonably pay if neither one were under any pressure to sell or buy. Generally, assets are valued as near as practicable to the time of trial. This can be confusing because the characterization of an asset is based on date of separation, while the valuation is based on date of trial. For example, the characterization of interest in a pension would be as of the date of separation. However, the value of the interest would be near as possible to the date of trial. In some circumstances, the court can order a different valuation date. This is usually done because one party has done something to cause the value of an asset to greatly decrease or increase after separation, not just to overcome the fluctuations in market value not caused by the actions of a party. To obtain an alternate valuation date, a party must make a motion to the court and explain why a valuation date other than time of trial is appropriate. The value of an asset can be determined by expert testimony, by the opinion of a party, by an agreed-upon appraiser, or sometimes by commonly relied upon sources, such as a Kelley Blue Book. Parties often agree to jointly hire a professional to value assets, such as retirements, businesses, and real property. Absent an agreement of the parties as to their own division of their assets and debts, the court must divide the total community estate so that the net division is equal between the parties. This equal division can be accomplished by valuing the assets and debts, dividing them as equally as possible, and then ordering one party to pay to the other party an equalizing payment so that the net division is equal. When possible, the court can order an in-kind division of an asset or debt. This means that each party receives 1/2 of the community portion of the asset or debt. All types of property cannot be divided in kind. However, such assets as pensions and bank accounts and most unsecured debts can be divided in this way. The court also has the power to order that an asset be sold and the proceeds divided between the parties. When the net value of the community estate is less than $5,000 and one party has not participated and cannot be located, the court may award the entire estate to the other party. There are some special rules for division of certain types of assets and debts. Personal injury awards are subject to special rules pursuant to Family Code Section 2603 and are usually assigned to the injured party even though the injury may have occurred during the marriage. Workers' compensation awards are the separate property of the injured spouse. Retirement benefits or other deferred compensation benefits are generally divided pursuant to the time rule. To the extent the benefits are earned or contributed during the marriage, they are community, along with any accumulations on the community contribution. If the parties are going to divide the count in kind, so that each party receives 1/2 of the community interest, a document called a Qualified Domestic Relations Order, or quadro, will need to be prepared in addition to the final judgment. You will probably need an attorney or other professional to prepare the quadro. Student loans are subject to a special rule pursuant to Family Code Section 2641. Generally, the spouse who obtained the education takes the loan with him or her upon divorce or separation. The exception to this is the situation in which the community has substantially benefited from the education prior to separation. In a related issue, the community may be entitled to be reimbursed for contributions to the education and training of a party, unless the community substantially benefited from the education or training. A debt which was incurred during the marriage, but to the detriment of the community, will be assigned to the party incurring the debt. Often, a criminal fine or restitution will be assigned wholly to the party who incurred the debt. Support arrearages owed for other relationships will be assigned entirely to the party owing the support. Some situations are so complicated a party should not try to determine the valuation and division of an asset without assistance of a professional. Businesses are difficult to value, and there are several different methods commonly used to value businesses. If the business is part community and part separate, the situation becomes even more difficult, as it is not always easy to determine what portion of the business is attributable to the community efforts and what part to separate efforts. Termination pay or severance pay may be difficult to divide because the characterization depends on the underlying basis for the payment. To the extent the pay is to compensate a party for future earnings, it is separate property. If it is in consideration for years of employment during the marriage, it is community. It is not always easy to determine what the basis is for the payment. Military retirement benefits are subject to federal laws, and while divisible in a divorce, have special rules to protect the service member and also to protect the service member's spouse. It may be possible for the spouse to obtain direct payment from the military if certain limitations on length of marriage and time in service are met. Similar to civil retirement plans, an order for division of military retirement pay must be prepared in addition to the final judgment. This video has just touched on some of the basic rules which apply to the characterization, valuation, and division of the community assets and debts of the parties. In many cases, the parties can agree to divide their assets and debts without concern for the equality of the division. The family law facilitator or a private mediator can assist in arriving at and preparing an agreement. If there is no agreement, the court must divide the community estate equally at trial. Each party has the burden to provide to the court evidence as to the characterization and valuation of the property in dispute. Going to trial can be difficult and frightening for a self-represented party. If at all possible, the services of an attorney should be used for trial. For more information on this topic or other family law topics, you may view other video workshops, visit the Family Law Self-Help Centers at the courthouse, go to the Self-Help section of the Judicial Council website at www.courtinfo.ca.gov. This workshop was designed to provide basic information to help you help yourself if you are not represented by an attorney. It is not intended to replace in-depth legal advice specific to your situation, which can only be obtained from an attorney.